I'm to give you an update on the case brought by Mr. Glenn Lau on certain provisions of the Petroleum Agreement of 2016. The first point I'd like to make is that I have no direct role in the legal action, and so I am presenting my views from what I have read of all the papers, and I have to admit that I've seen all the various submissions by all the parties. Just a brief timeline. The case started in January, and we are now moving towards the presentation of limited oral arguments sometime next month. Between January and now, we've seen ESSO applying to be joined as a party, along with the Attorney General. We've seen submissions exchanged, and I would say that we've also seen a delay arising out of a request by the other parties, ESSO and the government, that they needed to consult with international lawyers for assistance. The matter is indeed moving along quite rapidly, and we are, as I said, we're moving towards it's moving towards oral presentation. I would not be surprised if this matter, if the judge rules before the end of the year. One can dare to hope that the ruling will be favorable. Now, to the action itself. What Mr. Lau sought to do was a very narrow scope. Is that he asked for a few questions on taxation only. Whether the tax concessions and tax waivers granted in Article 15 were in line with the authority granted the Minister of Finance under the Petroleum Exploration and Production Act. Whether that those concessions apply to persons other than the oil companies, and that meant affiliated companies, subcontractors, expatriate employees in certain cases. In their response, or their responses, the government and ESSO have raised several procedural points in addition to the substantive defenses. I'm sorry, I hope that's not being too technical. They've raised masses of procedures and said, look, you've come by way of the wrong route, or you've used the wrong procedure, or Mr. Lau is not authorized to bring this action. So what I'll do now is just briefly go over some of the points that raised. In the latest submission on behalf of the Attorney General, they raised two preliminary points. They said the court's dealing with the standing of Mr. Lau to bring the case, and the second was whether the case is a matter of private law or public law, and that would have determined how it should have been brought. The extent of his arguments on those 2 points, however, is that, look, those are my submissions on those 2 issues, but I'm relying on the submissions made by ESSO to buttress or to justify my position. There then is the question of another issue raised by the Attorney General, the power of the Minister to enter the contract. Our position is that he is entitled to enter into petroleum agreements, but the critical words in the section of the Act giving him that authority not inconsistent with the Act. The HE relies on a Belize case stating the Minister has prerogative powers to enter into agreements. The second issue was the breadth of concessions. So we don't agree with Mr. Lau's team does not agree with the submission by the Attorney General. The other issue at the breadth of concessions, whether the the concessions and waivers under the Petroleum Exploration Production Act extended to persons other than licensees, and I think a lot of emphasis was placed on words in relation to. In paragraph 14, the Attorney General goes on to say that the true and real intent of the provision of the Act allowing for certain waivers was to insulate the petroleum operations which are the subject of a production sharing agreement from taxation. Incredibly, the government argues that a licensee is simply the holder of a license and may play a very indirect role in exploration, appraisal, development, and petroleum and production of petroleum. He argues that the controversial provision should be read in the context of the statute as a whole. This, in my respectful view, is devoid of logic, law, or reason. The other issue raised is the question of the power of the Minister of Finance. Just for the audience, there are two ministers engaged usually in relation to these matters. The first is the minister who deals with petroleum, who is assigned petroleum responsibility. And the second, he enters into an agreement. The second minister is the Minister of Finance, who is supposed to give effect to Section 51 of the Petroleum Act, which says that certain modifications to the tax laws can be made. The issue raised by the AG, in my opinion, is this inexplicable assertion that Lal was suggesting that the minister did not have the sanction of Parliament in granting his concessions. That, from my reading, is not what Lal's attorney was saying. Lal's attorney was simply saying that whilst he had the sanction of Parliament, he acted outside of the confines of the law, vesting him with such a power. The next point, we had raised, I must be careful. The question was raised about discrimination in the submission. The question was, the issues were subsequently withdrawn. Yet, the AG spent 13 paragraphs dealing with that issue. And, I think that there's no need to say anything else about discrimination, that there's not a discrimination in the context of the Constitution or the Prevention of Discrimination Act. A further point, and a couple more points I'm going to raise in what Mr. Lal argued through his attorney, was that Mr. Lal, had failed to act promptly in bringing the action. What Mr. Lal had said from earlier talk, that one of the reasons he took some time to bring the action was that he was relying on a promise made by the very government of which the Attorney General is now a part. So he was relying on their promise that they would renegotiate the contract. Now, the AG is using his government's reneging on that commitment to say, look, you have delayed, so you can't come now. The other point was one on policy and rule of law. The AG argued that third parties, presumably subcontractors, would have entered into contracts of varying value with the contractors involving tax concessions granted by the Guyana Revenue Authority, and that these persons have a legitimate expectation requiring protection of the law. Now, apart from the lack of any factual support for this proposition, it is completely wrong to suggest that the GRA has any power to grant tax concessions. In fact, one of the things I noticed in the AG submission, they kept referring to a wrong act, but that's a small part. In my view, what the AG has signally failed to do is to respond to Mr. Lal's case that a modification of tax law cannot by any stretch of the meaning of the words, that a modification can mean, oh, you don't want to pay me tax, I will pay that tax for you. That has not been addressed either by Mr. Lal or Exxon, in fact. I now go to the issue of the points raised by my SO through their attorneys, 3 high-level senior counsel, I should add. SO dares to tell Glenn Lal, a citizen, a taxpayer, and a newspaper publisher, that he is not entitled to bring proceedings for declaratory relief alleging a breach of public rights, and in any case, he has not shown any special loss or damage. I don't know if they realize that taxes have to be made up by some form. There was a lot of discussions by SO's attorneys whether the proceedings brought under one form could be converted to another form, whether the relief sought should not have been brought under a different legislation. The question of undue delay was also raised, the question of the locus standi, and here again, the absurdity of ExxonMobil, a branch of a company incorporated in a tax-free jurisdiction that is a subsidiary of a US corporation, telling a Guyanese citizen he cannot go to the court to ask for a declaration of the propriety and effectiveness and the legality of legislation. They argue then that the applicant's application is neither justiciable in law nor can it be converted into judicial review proceedings. Essentially, SO's argument seems to suggest that the matter ought not to be brought to court in any prescribed form. One of the arguments we saw early in reading the documents, that look, the only person who's going to bring this action is the Attorney General. Well, the Attorney General is the one objecting, so I don't know who else is going to do it. SO also dealt with the substantive issue of the tax concessions and tax waivers. Now, and they said that they claim that the use of subcontractors and affiliated companies is a universal practice vital to achieving efficient, cost-effective petroleum operations. I don't know if they were aware or the attorneys were advised that in making their application, they claim to have all the resources to enable them to carry out petroleum operations under the agreement and under the respective licenses. Now, I give SO credit to be bold enough to confront the elephant in the room. The minister and the government of Guyana paying the taxes of the oil companies. But Lal in his submission had stated it is unknown to our tax laws for the government to pay the taxes of a taxpayer, as Article 15.4 purports to do. Nowhere do they refer to the relevant provisions and the relevant act, the applicable act, under which tax expenditure, tax concessions, tax waivers, and tax reliefs can be granted, the Financial Management and Accountability Act. So cleverly, they then seem to support Lal's position that paying the tax is not a waiver, remission, or concession, and that Glenn Lal had cited no authority which prohibits such contractual agreement between the parties. To the best of my knowledge, Mr. Lal made several references to the Financial Management and Accountability Act. So I don't know which authority SO and the Attorney General are seeking when there is a statutory rule within the tax laws of Guyana. And further, and this is my opinion, I don't know what Lal's attorney would say, Section 51 of the Production, Exploration and Production Act, under which the tax concessions are purported to have been given under Order 10 of 2016, simply says you can modify. Are you going to turn it on its head and say, okay, we modify it to the extent you don't have to pay us anymore, we gonna pay it for you. We will go and tell the station, look, take we money and pay it for you. I don't see how that is reasonable. The second point I want to make on that, pepper, can I get a glass of water, please? I'm sorry. You know, you have water on your side, unfortunately, and vegetarian food. I don't have that. The pepper is not a tax act. If one reads, and you know the lawyers keep talking, look at the purpose and look at all of this. If they read, they will see what that act is all about. And to rely on matters and incidental matters thereto cannot make it into a tax act. Now, I'll close. I don't want to talk about my time. Lal must now, thank you. Lal must now respond to the submissions made by the government and Exxon, which are becoming indistinguishable in relation to the case and in relation to oil production in Guyana. That's going to require some extensive research. A lot hinges on the outcome of this case. Had the oil companies been required to pay taxes on the 2021 income, the country would have received taxes from them of 78 billion Guyana dollars. Let me repeat that, 78 billion Guyana dollars. Incidentally, that money has to come out from the Natural Resource Fund. So when we talk about the Natural Resource Fund, we have to talk about that money that has to come out from it. The Commissioner General needs to get the actual money. And because the 15.4 says the money is paid out of the fund to the Commissioner General, who then issues a certificate. My view is, and that's not directly related, that's not before the court. I think the government and the GRA have improperly dealt with this matter. SESA should not have issued a certificate of taxes paid unless the money had actually been paid. But I want to make a final appeal. And by the way, I mentioned 78. I don't know, I think it's well over $100 million, $100 billion for the oil production in 2022. And it's going to go much higher. Of course, it depends on how oil prices were to perform. But even if it stays at that 78 billion or $100 billion for this year for some time, how great it would be for Guyana and all Guyanese if the court rules in Mr. Lal's favor on the single issue of the payment of taxes by oil companies. One knows that Exxon will now have to pay 15% tax in the United States of America. And guess what? If we rely on our certificate as Hess did to show that it paid taxes around the world. Hess paid no federal taxes in the United States, but the recorded taxes paid because of what they got by way of a certificate from Guyana. Now, I want to make an appeal. It's really encouraging to see this level of support. But we really do need to have a fund. I don't know if you realize it, but the money that ExxonMobil is paying for these to fight Guyanese is a deductible expense under paragraph H of section 3.1 of the agreement. Legal expenses in defending or prosecuting lawsuits involving the contract area or any third party claim, etc., etc. That's what the agreement says. I am appealing. We need to have between 10 and $15 million. If this matter has to go to the Court of Appeal and then to the CCJ, it's going to need money. This case means a lot to Guyanese, both at home and in the diaspora. The excellent arrangements have taken place in sponsoring today's activities, maybe a dinner, a fundraising activity, or some other thing needs to be held to raise some money, and to raise some money very urgently. Those are my submissions, please. Thank you very much.
Yeah.